Our documentaries on intellectual property. What is intellectual property? Property and its ownership is a very important facet to understand when dealing with business law. But what happens when ownership extends to intangible creations of the human mind? This is called intellectual property, or IP for short. Throughout the rest of this short documentary, we will break down some of the most common types of intellectual property, explain some of the relevant law and legal sources, and give a case example of how the courts deal with intellectual property. The role of IP in society. Although intellectual property can be found in just about every modern society, it is especially prevalent here in the United States. You can see it on television, the internet, in books, on the freeway, and in numerous other places. Since intellectual property is intangible, the primary reason for why IP rights are respected in American society is because it is thought to benefit society by encouraging creativity and other intellectual goods. As the logic goes, if people's creative endeavors can be appropriated by others without due credit, there will be less of a reason to engage in such creative endeavors, especially when such endeavors are of an entirely artistic nature and lack a practical purpose. Intellectual property is split into several different types, of which this documentary will focus on some of the most common. Trademarks can be thought of as some sort of symbol that identifies a form of product or service as originating from a specific source. A trademark might traditionally consist of the name of the producer of a product or service, but phrases and pure symbols can also be a trademark. The McDonald's Golden Arches logo, the Coca-Cola, and the phrase "Just Do It" are all different trademarks. Since the goal of a trademark is to distinguish one producer from another, if one producer were to appropriate the trademark of another, causing confusion and unjust enrichment, this would typically constitute trademark infringement. Sources of trademark law can be governed. Trademark law can be governed by federal as well as state law. However, as is the case with most intellectual property, federal law is by far the most important. In this regard, the primary source of trademark law is the United States and the Federal Lanham Act. This act establishes how businesses may register their trademarks and establishes civil remedies businesses can pursue against those who violate their trademark rights. Trademark law is also impacted by decisions made by the United States Patent and Trademark Office, an agency within the Department of the Treasury tasked with administering laws related to trademarks among other duties. As their name implies, they also deal with patents, which will be covered later on. A case example for trademark law is UCS versus Nintendo, uh, and UCS being Universal City Studios, a 1983 case. This impetus of the case was Universal's claim that the character Donkey Kong, an antagonist in Nintendo's classic arcade game of the same name, violated Universal's trademark rights to the character King Kong. Was Nintendo guilty of trademark infringement? No, according to the New York District Court. The court came to this decision based on a prior legal case involving Universal, in which Universal themselves argued that the King Kong character was in the public domain and that they therefore had no trademark rights. The court also concluded that although the characters were similar, King Kong and Donkey Kong were sufficiently different enough that it would be unlikely that consumers would be confused between the two characters. Now we're going to copyright. Having taken a look at trademarks, uh, next type of intellectual property being copyright. In simple terms, copyright refers to a legal right given to a creator that gives them the exclusive, albeit temporarily limited, right to make copies of their work as well as derivative works such as sequels to a story. Copyright can take many forms such as movies, music, video games, works of literature, and many others. Copyright does eventually expire, although the trend in the United States law has been toward longer copyright terms of nearly 100 years, although varying criteria have to be taken into account. Like with other forms of IP, copyright is designed to promote creativity by giving copyright holders rights how their work is handled to ensure their ownership. Fair use exceptions. Considering copyright is otherwise heavily stacked in favor of the copyright holder, there are also certain exceptions for liability concerning the usage of copyrighted material by other people apart from the copyright holder. These are known as the fair use exceptions and come into play if the reproductions are made for the purpose of criticism, commentary, news reporting, teaching, scholarship, or research. These criteria are also considered with other factors such as the nature of the use of copyrighted material, how much is used, and how it may affect the market for the copyrighted work. For example, playing a short clip of a movie for the purposes of demonstrating a critique of it would likely be protected under fair use. Sources of copyright law. In the United States, the ultimate source for the copyright law is found in Section 8 of the U.S. Constitution, which states that Congress has the ability to secure for limited times to authors and inventors the exclusive right to their respective writings and discoveries. This section also provides for patents, which will be discussed later. Congress has exercised this power by creating laws which deal with copyright, of which one of the most important today is the Copyright Act of 1976. Similarly to trademark and patents, copyright is also dealt with by a government body, the United States Copyright Office, which is tasked with administering copyright law and the registration of copyright claims, among other functions. Case we're going to look at dealing with copyright law is the Hatchet Book Group versus Internet Archive, in which a publishing company alleged that the Internet Archive, a nonprofit organization dedicated to archiving, committed copyright infringement by lending complete copies of their books. The Internet Archive had leased these copies through a controlled digital lending mechanism, which was thought to be analogous to physical libraries leasing books, which would not ordinarily be considered copyright infringement. However, the New York courts disagreed and ruled that the Internet Archive had indeed violated Hatchet's copyright. Part of their reasoning was that the online copies distributed by the Internet Archive had harmed the market for Hatchet's books, and that the usage was commercial in nature, and because the Internet Archive had solicited donations and gotten involved in partnerships with other book companies. What are patents? Patents are a type of intellectual property that are similar to copyright in many regards, but focus on protecting an inventor's ownership over their invention or design. As with other types of IP, the goal is to ensure that inventors are rewarded for their work by protecting their rights to their inventions from being appropriated by others unfairly. While copyright generally deals with artistic works, patents generally deal with works that have practical applications, which can consist of machines or other compositions of matter. Patents can also apply to manufacturing processes or improvements to prior inventions. As patents can only apply to things that have been invented, they cannot be applied to naturally occurring objects or phenomena, as well as abstract ideas. Like copyright, patents are temporarily limited, but unlike copyright terms, which as of now can last close to centuries, patent terms are limited to 20 years for inventions and 14 years for designs, after which the patents will become public domain. This makes sense as patents can often have great public utility, and longer patent terms would allow for monopolies on extremely important emerging technologies. As was the case with copyright, patents get their legal source in the United States from Section 8 of the U.S. Constitution. The specifics of patent law are dealt with in Title 35 of the U.S. Code, which clarifies what can be patented and the requirements for patentability. The primary federal organization dealing with patents is the previously mentioned United States Patent and Trademark Office, or USPTO, which administers laws relating to patents and granting and storing patents. An example of a legal case dealing with patents is the Supreme Court case of Diamond versus Chakrabarty. This case involved a dispute between the USPTO and a geneticist named Anita Chakrabarty over whether the genetically engineered bacteria Chakrabarty had created could be patented. The law had traditionally held that patents could not be applied to living organisms, but Chakrabarty argued that he could be allowed to patent his bacteria as they had been artificially created rather than naturally occurring. In a landmark decision, the Supreme Court agreed and ruled that artificially constructed organisms could be patented under their interpretation of Title 35. This decision would have major ramifications for further developments in the field of genetic engineering, as geneticists could have their creations receive legal protection that they were unable to obtain beforehand. While intellectual property may be intangible, it is undoubtedly an important aspect of modern business, especially here in the United States. Indeed, the protections offered to intellectual property in many ways may be the bedrock of the modern business world. Without such protections, many of the technological and cultural developments across the globe may not have happened. The simple truth is that money makes the world go round, and if creators could not have their creations protected with intellectual property law, most would lack the incentive to exercise their creativity and share it with the world. That we have for our documentary.